My name is Bob Garvey. I'm an attorney in Saint Clair Shores, Michigan. I have a statewide practice in personal injury law. One of the areas I limit my practice to is automobile negligence cases. Michigan has sort of difficult to understand, but really not if you get the idea that every auto accident presents the opportunity for two claims. Most importantly, you generally, if you're injured in an auto accident, you will generally go to your own insurance carrier for three benefits. The first and most important is that you have medical coverage for the rest of your life without regard to fault. So if you're seriously injured in an automobile accident, Michigan is, I hate to say, a great place to be involved in an auto accident, but in terms of the protection and the coverage that you have, it is, because you have coverage for the rest of your life for medical bills, as long as it's related to the accident. Second thing you have in Michigan, if you're involved in an auto accident, if you suffered wage loss, there's coverage for wage loss for up to 3 years, 85% of your former weekly wage, and it's non-taxable to you. The third benefit that you have in Michigan from your own insurance carrier without regard to fault are what are called replacement services. These are household services: cooking, cleaning, shoveling the snow, cutting grass, raking leaves, dishes, cooking. They'll pay up to $20 per day for up to 3 years. Again, that's your own company, your own insurance company. It's without regard to fault. There are instances where you go to the other person's insurance company, but in the vast majority of time you're going to your own insurance company. But you may not have insurance, then you're going to go to another carrier. The second case, remember we talked about two cases. The second case that you may have in Michigan as a result of a motor vehicle accident is what people traditionally think of as a lawsuit. I'm disabled, I have chronic pain, I have a closed head injury, I've lost the function of my hand. Those are terrible injuries. And you experience pain and suffering and concern and worry. You can sue the driver, the at-fault driver of the auto accident, in addition to getting these benefits that we spoke about from your own company. So in that second case, where you're suing for your pain and suffering, your mental distress, your disability, the fact that you can no longer engage in sporting activities, you have to demonstrate that you've had a serious injury. They call it a serious impairment of a body function. Once you establish that threshold injury, is what they call it, you can get all of whatever's reasonable for your pain and suffering, mental distress, disability. So that you would have to show fault in that case, and you'd have to show a certain level of seriousness to your injury. And of course, that's where your lawyer comes in. And we limit our practice to personal injury litigation. I personally taught that course for 7 years at the University of Detroit Law School. So I think I know what I'm talking about when it comes to no fault. So if you have those questions, please give us a call. Thank you.